Welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you determine whether or not you need or want to contact a lawyer. Perhaps will help you decide that you can handle some issues yourself. If you do need outside professional counsel, you'll be better prepared, and so will the professional you select. Of course, our goal either way is for you to achieve the best possible results while saving time and money. The Bazar & Associates law firm in East Providence continue to help us every week. Welcome, David. Attorney David Bazar. We want to thank them, of course, the firm, for their continued support and their insights and perspectives on the various topics that we tackle. And today, our topic will be, timely enough as it is in January, bankruptcy, what it can do to you as well as for you. What are the differences between Chapter 11 and then the 7 and 13 and the rest? And what's loss mitigation versus the bankruptcy? Which one's working for you? I suppose they say that's supposed to be the court of last resort for you to be bankrupt. What's an exemption? How do you get one or more? So whether you're individual, couple, business, this segment is for you. There are lots of things that we want to cover today, including some of the basic frequently asked questions, but also some of the nuances. So, David, let's go through the tutorial, as I usually ask you to do as we begin. What is bankruptcy, and how is it done?
So, bankruptcy is sort of the federal government's way of saying you've really dug yourself in a hole for some reason, no fault of your own, and we want to give you a fresh start. And as you mentioned, there are different chapters of bankruptcy and different ways of doing it, but overall I've acquired a lot of debt either through an illness or some other thing that I wasn't expecting, or just you said January is a good time to talk about it, maybe Christmas bills or something like
planning.
that. Yeah, poor planning. So I've acquired a significant amount of debt over time, and I'm getting dragged down by it. I can't afford it anymore. How can I get a fresh start? And so bankruptcy is one way of providing you with that fresh start.
So there's 7, there's 11, there's 13. What are the distinctions, and who should do what when?
So a Chapter 7 is usually the bankruptcy that most people think about and know about. And it's, I have all this debt, I have this amount of income which isn't enough to support that, and I have very little of any assets, and what assets we can talk about what's protected and what's not later, but I have a situation where I just need to wipe out the debt. And so after you go through an analysis of what the debt is and whether it's dischargeable or not, your attorney can tell you, all right, this is what you qualify, and under Chapter 7, this is the amount of debt that we can just eliminate. And so Chapter 7 is really a process in which most of your debt that's eligible gets eliminated.
When the term complete liquidation is used, what does that refer to?
Well, there could be different types of things that you're talking about. A complete liquidation for a business in a receivership, for example, would be you liquidate all your assets, you pay off the assets, the debts from the assets that you have, and if there's anything left, it's distributed. In bankruptcy for individuals, that's not something you're usually looking at because you're not liquidating assets that are exempt from being subject to attachment in a bankruptcy.
As in, am I going to forfeit my home and my car? But you can get into that.
Right.
So I was asking the distinction. So 7, the one that most people are familiar with. 11 and 13?
So one's business, one's individual, and they're bill paying sort of plans. You add up all of the debt of the business or of the individual, and a trustee comes in and says, I'm going to take the assets that are not exempt, I'm going to take income that's not exempt. You're left with some income to pay your living expenses, and then whatever is available above and beyond those exemptions, the trustee will use to put together a plan, and the plan might pay 50 cents on a dollar to the the creditors. Now, remember, there's also differences between secured creditors and unsecured creditors and how that all works. You want me to explain that?
Why not comment on that, sure.
So a secured creditor is a creditor that has a security interest in an asset. In an individual, the biggest one you usually think of is a house, mortgage. Sometimes it's an automobile, car loan. Business, it could be secured loan for machinery, equipment, furniture, that type of thing. So a secured creditor is given a priority because they have that security interest in that particular asset. So here's where you go, where you're asking, I'm an individual, I'm filing a bankruptcy, can I keep my house and my car? Well, if your situation is such that you can afford to pay the mortgage and or afford to pay the car, then you can, yes, continue to pay those debts so they're not wiped out while all the other debts are in fact wiped out.
So we say that we want to help people who want to perhaps handle some issues themselves. If you are completely giving up, want to file bankruptcy, no reorganization of anything, is it possible for someone to go to a bankruptcy court, pay, is it $300?
It's a large filing fee.
Is it 300 more? I'm not sure.
Yeah, it depends
on where. Is that something that someone could do on their own if they just want to wash their hands of everything completely? And if they can do it, should they, or why shouldn't they?
It's not a process that you should do on your own. There are little nuances to certain things of what might be exempt, what you might be able to keep, what needs to be reported, and the bankruptcy court needs to know everything, so you have to disclose everything. So I, in my office, have an attorney that does bankruptcy. I won't even go through a case and do it myself. I have my bankruptcy attorney do it because even though I know the generalities of the whole process, and I used to do it, so I know what we used to do, it changes. And so you want to bring in an attorney who does bankruptcies and nothing really but bankruptcies, or it's the primary part of their practice, because things change, there are different nuances. You know, two bankruptcy attorneys can look at a debt or an asset and make somewhat of a different determination. So you need to be able to have someone who knows what they're doing.
Would those differences in their determinations have anything to do with what an exemption might be?
It might have to do with an exemption, although those are pretty well spelled out.
Okay.
But it also might have something as to how you might classify something. Is something an asset? Is it income? You know, is an IRA exempt? Pretty much it is, but are there ways that it might not be, or does it create problems with income? If you're taking a mandatory distribution in an IRA, is that income that gets included in the calculation as to whether or not you're eligible to file bankruptcy? There's a lot of factors that go into this, that it's not a do-it-yourself job.
Point well taken. So at the top of the segment, I said that's supposed to be considered as the court of last resort. Meanwhile, if you are overdue with your, I guess, credit card bills are the things that I was referring to when it comes to January,
Right.
and often credit card companies and some other creditors hire people to harass. What can you say about how that works?
So you hear
Options?
these options, and I've spoken to some attorneys who are more familiar than I am with them. And under the right circumstances, they can work, and you can consolidate your debt in one form or another, and in fact, wipe some of it out. So as I understand how many of them work, it's you have a pile of debt and many different credit cards perhaps, and they are going to say, okay, you're going to pay us one monthly amount, and we're going to go out and negotiate what is getting paid. So you pay us, and we're going to pay off your debt through a negotiated settlement of whatever it is. So that what happens is you do end up paying less. They're making a profit because they're charging you more than they're actually negotiating everything out. So the question to me then became, well, can't you do that, and can't you negotiate those things? And to some degree you can, but this is something they do all the time, so they have pretty good success at it, whereas sometimes they're not going to talk to you individually. But long and short is you can attempt to negotiate your debt yourself, or consolidate debt and lower the payment through a loan if you can do that, or take some other steps, even with one of those companies, before you file bankruptcy if you want to avoid the last step of filing bankruptcy.
Is there a number, is there a total amount of money that you should think about having hit before you should consider filing for bankruptcy? If you had $15,000 of credit card debt and you made 40, I don't know. Are there such numbers? I don't know that anything is hard and fast and solid, but is there any kind of guideline that you could proffer for us?
So I don't think I could tell you this is a number that you need minimum for debt, and this is the number of dollars you make that you want to do that. But because every situation's individual, and you have to look at that. But I will say that you have some numbers that you can bear in mind. If you're $5,000 in debt and you have some income and you can pay it, you're not going to come in and file bankruptcy for that, because you're going to spend more than that between the attorney, well, not more, but you're going to spend a good portion of it on an attorney and the bankruptcy fee and all of that to save what? That's not going to be worth it. 10,000, depends. What's your life? What's your lifestyle? What is it that how is it affecting you? So I think that those numbers, those smaller numbers, might be a good point with a company that will negotiate the debt for you, or to try to negotiate it yourself if it is something that you can't handle. But as you get to a larger number and it's just eating up all of your income, then that's when you're looking at the bankruptcy part of it.
What advice can you give to those who listen to radio, television, see ads in newspapers about got debt, we'll fix your problem, make it go away? Some of them may be legitimate, can help you reorganize, etc. How do you identify what a potential shyster is? What are some of the red flags you would give people?
I would tell you two things that I would do. One is I would call the Better Business Bureau before I used any of them and find out what complaints, if any, there are, and whether they have a rating with the Better Business Bureau as one thing. I might also call a bankruptcy attorney and someone who's in the trenches doing this all the time and may have history or some experience with some of those companies from clients who've come into them who've either tried to use it or are attempting to use it, and they should be able to give you some good advice on that.
Okay, good enough. So what can filing for bankruptcy actually do for you? We know that there are stigmas that are way against you. Your credit's ruined for X years. I've heard in some cases you may end up having that stigma last 8 years versus 5 years. What are some of the things that it can do to help you, though, apart from getting rid of some debt, which is the goal?
It gets rid of your debt, which is your goal. So it's supposed to put you back on, as we said, a fresh start, new footing, to be able to not incur new debt again, so that you'd have to file bankruptcy again. So some of the different years and things you're talking about is, how long is the filing of a bankruptcy carried on my credit report? Well, that's where there's years less than 10. 10 years is usually the number of years it has to go by before you could file again. And is my credit ruined forever? So no, your credit's not ruined forever. There is a report that's going to show on your credit report that shows that you filed bankruptcy. But in some ways, you're a better credit risk than many other people, because you can't file bankruptcy again for a number of years. So that's something to bear in mind. And there are credit companies that are designed to help deal with you in a fresh start, to rebuild your credit. And it might be a credit card that they'll give you the credit, but you need to have the money in the bank to secure it in order to qualify it, and that credit line will eventually grow as your credit is reestablished. So there are many ways of reestablishing credit.
Does it make sense that if you hadn't paid, which puts you in arrears anyway and makes you feel like you're underwater and just can't get out from under, you have then on your credit report, bad report for however many months, plus accruing interest and penalties and fees or whatever else they have? Might that do more to damage your credit rating than sticking the bankruptcy and just putting an end to it and then starting over again with what you've suggested?
Well, if someone's come in and they are behind on everything, and falling more and more behind on everything, to the point where they're getting threatened with lawsuits and other types of action and constant harassment. Then they're at the point where the bankruptcy is not going to affect that credit as much as someone who comes in who's been paying every month but just says, I can't continue to do this, or I've been trying and I'm paying minimums on it or whatever.
So David, in terms of how it would benefit you, I guess we could say that the filing for bankruptcy will keep the debt collectors from your door. How does that actually happen? Do you have to say to each and every one, I filed for bankruptcy, and hang up the phone, or do they all get notified?
Well,
as part of what
they do get notified, but if they continue to call, then you absolutely tell them, I filed for bankruptcy, please do not call me again, because they're not allowed to call you after you filed.
So there is an advantage. So what can bankruptcy not do to help you? And I'm thinking if you could go over things such as, oh, I don't think I can afford my alimony and child support and college loan. What things, how does that work?
Those are debts that aren't subject to discharge that we talked about before. So if somebody is under an alimony or child support order through a court, and they want to come in and say, I don't want to pay that alimony anymore, it's not dischargeable in bankruptcy. So even if you have other debts that are dischargeable, you're not going to discharge the alimony payment or the child support payment. So it's not going to help you with that. If you have a really big mortgage and you just want to wipe the mortgage out, but you want to keep the house, it's not going to work, because the house is secured by the mortgage. And so if you file for bankruptcy, eventually the bank is going to be able to take the house back. Not right away. It's a way of staving off a foreclosure if you're behind on your mortgage payments, and buying some time to try to negotiate. A lot of times back when we were having a lot of mortgage issues and financial issues, people were moving for loan modifications and that type of thing. And so bankruptcy won't get you that, but it might buy you time to be able to do that. If you have to do that, if you're at the point where you're facing a foreclosure or something like that. You're not going to be able to, for the most part, wipe out taxes and student loans, but I'm going to say, but each individual situation is slightly different, so you need to talk to a bankruptcy attorney over the phone or in person about your particular situation, because generality, taxes and student loans aren't subject to bankruptcy discharge, but yes, they are in certain circumstances. So you need to explain the circumstance individually.
So you had said that bankruptcy is a federal issue, but of course there are things that vary state to state.
Correct.
So might someone fare better if they were in this state versus that state?
Yeah, so when you file bankruptcy, there are exemptions that you can claim. And the exemptions are different in each state. There are federal exemptions or state, and so you can decide which ones you're going to claim.
I can imagine that's not something that you'd want to have to decide yourself, where you definitely would want an attorney.
Well, and that's what I was talking about. When you go to an attorney, they can tell you, you're better off using the federal exemptions in your case. You can save this, 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 and this. Sometimes it's the state, and we have a homestead exemption, and different states have different amounts, and how much can you have in equity that you can save in the house. So those are all very important things to know, and it does vary state by state on the state exemptions and federal exemptions. So there's a lot of exemptions that can be put in place. Save my retirement account, save my house, save my personal injury case or a portion of it. Those are all different things that can fall into place. There's a wild card exemption that can save a certain amount of money for anything.
Good to know. A moment ago, you started to speak of having to stay in your home, the ability to stay in your home. And when we had the issues with mortgage and loans, there was an issue about how remediation was done and how remortgaging was done. Maybe this is a good time to speak a little bit about what the idea of what loss mitigation is. So, and nothing fraudulent, but how does loss mitigation work?
Well, it depends exactly what you're referring to.
Mostly the loan modification.
Yeah, so loan modifications.
Yes.
Loss mitigation maybe for the bank, loan modification for you. So, yeah, and that's what I was referring to when there was a high number of defaults in mortgages, and the states put some rules in place. There were federal rules in place. And the banks were supposed to be willing to sit down and talk to you about modification of the loan so that you might pay a lower amount and pay more over time, but whatever it is, there are lots of different ways to reduce the monthly payment so you could stay in the house. Those things, there were also some rules that sunset in some of those things in terms of, well, if you were to default on the loan, but they were going to forgive you the deficiency, the difference between what you owed and what the house was worth, the government wasn't going to treat it as income. So there were a lot of different ways of getting out of bad loans. Same thing, it's very similar to what we were talking about with credit card debt and negotiating the loan or the repayment of the debt that you have to the credit card company. So loss mitigation for the creditor, we don't want to lose the whole amount through bankruptcy. Modification for the debtor to say, yes, I don't want to file bankruptcy, but I can't afford to pay the full amount.
What happens when someone declares bankruptcy and yet they went out and bought other things in the next 2 weeks?
Well, there are rules against that. And there's two rules I think maybe we should talk about in that. One is incurring debt within 6 months of the filing of the bankruptcy.
That's the prior to.
Yeah, so if you, prior to filing bankruptcy, go out and buy...
At a spree?
Yeah, go on a buying spree and use your credit card. That might not be subject to discharge because it was bought within a time frame where it's certainly reasonable to assume you knew you were going to file bankruptcy and you were just doing that to run up debt so you could have things before you filed the bankruptcy. That doesn't work. You can't also pay one creditor over another and say, I'm going to pay this creditor.
I like him, or they've been good to me.
Yeah, well, I have a
Whatever.
personal loan from mom or dad. I'm going to give mom or dad their money back and pay off that debt.
Yes.
And not my other creditors, and that's called a preference. So in a business setting, when you file a receivership or a bankruptcy, you have accounts payable, and if you pay all your accounts payable, but not all of them, you pick and choose, I'm paying this one, this one, this one, that can be considered a preference, and the bankruptcy trustee or the receiver can try to get that money back.
And then reallocate it?
And reallocate it to everybody.
Interesting to know. So for those who have been faithful in making their payments, maybe they lag a little bit, but then, as we know, healthcare is an issue. If you suddenly are hit with an illness, or your family member hit with an illness that then changes drastically, maybe not forever, but changes drastically your ability to pay, should that be an immediate trigger to do bankruptcy, or should that be something where you should definitely instead hire someone or do something so that you call each of those who are involved on the receiving end and try to explain it away? What are your suggestions?
Well, I will tell you that in sudden illness or catastrophic injury or a debilitating illness are things that are oftentimes the reasons people come in for bankruptcy. So we see that and we know that that's the case, but if you can get on it early, there might be ways of avoiding bankruptcy. So certainly talking to a bankruptcy attorney and getting what your options might be is a good idea.
Do they have more weight and clout so that you'd say it is worthwhile for them to get involved and make that call to
the creditor?
The creditor.
Absolutely. Yeah.
Good to know. When we talked about individuals or couples, suppose you're going to uncouple and you think, well, my assets are going to be divided, my income might change, I think I'll have divorce and then I'll have a bankruptcy filing. Maybe the other half is thinking the same. Do you get a twofer if you combine your debts and problems and file bankruptcy first and then get divorced later?
Yeah. So,
how does that work?
Finance is oftentimes one of the reasons people end up getting divorced. So a lot of times you will have couples that come in with a lot of debt and one wants to file bankruptcy, the other doesn't. How does that affect each other? The divorce attorney has to be well versed in what the effects of bankruptcy are on divorce and who can be held liable for what debt and how to deal with that. So oftentimes people are wise if there's so much debt to file bankruptcy as a couple and take advantage of that. Sometimes they don't do that though.
Okay. If you have children, you're divorced, you have children, and you've been paying child support, does the state, does the bankruptcy court make sure that that ends up being top priority versus said creditors, including your bank who has your house mortgage?
You're saying the child support?
Yes.
And yeah.
Is there a ranking order?
Well, child support's not dischargeable, so it's going to get paid no matter what.
No matter what.
And so, you know, I told you there's a ranking order of secured creditors and unsecured creditors, and in an employment or employer situation with a business in receivership, employees who haven't been paid their salary have a higher ranking than general creditors. So there's a whole number of priorities, I guess you would say, as to what gets paid. We talked about it in the state issues before, and I told you that in Rhode Island, funeral homes have the biggest lobby because they're always first. So at cost of administration in bankruptcy, if it's going to be a reorganization, you know, 13 or 11, the cost of the administration is a priority, and then all the other creditors in ranking come through. So child support is one of those things that is non-dischargeable and would be a priority payment.
Let's talk about costs in a different way. How about the career costs? If you file for bankruptcy, how does that impact on your security clearance, or even how you are perceived when you are applying for your next job? How does that carry forward or stay with you?
So it is an issue that can come up if you're trying to get a high clearance security job where they're going to run a background check and so forth, and that's going to come out. If you apply for a job where part of the application is a credit check, it's going to come out. So it's something to bear in mind. What is your job now? How secure is your job? Are you thinking of switching jobs? You know, those are some things you might want to play into your decision as to what you're going to do. But oftentimes there are other factors that will far outweigh your ability to say, well, that's the make it or break it point for me.
Without expecting a lawyer to be your personal HR counselor or public relations agent, can or how can a lawyer being involved with this help at all? Can a lawyer, I don't know, later get it expunged? Can a lawyer help in terms of providing any other insights or information or support?
Well, they can do some things, but it's not a criminal record, so it's not getting expunged. It's going to be on the credit reports, and so it'll be out there. But what an attorney might be able to do is help explain the situation. You know, it was the catastrophic injury or whatever it is that got you into that situation. That might be helpful to have somebody who is involved in the case be able to explain it for you to somebody.
And in the short amount of time that we have left, can most people usually plan on keeping their house at least, if not the house and the mobile home and the motorcycle?
Yeah, so long as you're willing and able to continue to make the payments once the rest of the debt is gone, you can always either reaffirm a debt if that's what you need to do, or just keep paying it in the case of a mortgage, so that they don't want to foreclose on you. They want to get paid, so as long as you're able to keep paying it, you can do that.
Good to know. Thank you. Thank you for tuning in to The Law Matters. We hope you will continue to tune in because the law matters to you.